Bonne soirée à tous et bienvenue à cette audience publique du Comité de dérogation pour la Ville d'Ottawa. Welcome everyone to this Committee of Adjustment hearing of the City of Ottawa. So the Committee of Adjustment is a quasi-judicial tribunal appointed by City Council to make decisions on certain types of applications under the Planning Act, most notably consents and minor variances, although permissions are also increasingly part of some of the decisions that we make, and we've got a couple of those this evening. My name is Anne Tremblay, and I'll be chairing this hearing this evening, but I'd like to also introduce my fellow panel members, Mr. Colin White, Ms. Julia Markovich, Ms. Kathleen Willis, and Mr. Scott Hindle. These meetings are not possible online without the great help of our staff, so I'd also like to recognize our coordinators for this evening, Ms. Cheryl Williams, Ms. Emily Monette, and Ms. Mandy Nguyen. And helping us through the evening, in addition to our coordinators, is our Secretary-Treasurer, Mr. Michel Bellemont. So I think many of you probably already know this or have taken note. We do live stream this hearing on YouTube. If you'd like to be able to see the presentation or the YouTube video at some point, you can always just go to the city's website. You can find the agendas and find any of the videos of previous meetings. I don't believe any have been taken down. I might stand to be corrected, but I think they're all there from the beginning of our COVID era, essentially. So the Committee of Adjustment has a lot of issues that comes before it. Unfortunately, our jurisdiction is fairly narrow, so we really do have to stick with the applications that are before us. So if there's something about an application or proposal that you're not comfortable with, but for whatever reason there's not a variance to the zoning bylaw standard, those are things that we really can't talk about because there's nothing before this committee to discuss on that level. We also can't talk about normal neighborhood issues with regards to noise or pollution or property maintenance or property values. We also don't address issues of prosecution for illegal construction because we deal with all the applications as if no construction has occurred. Also, we do not in any way entertain adverse comments about the applicant or the neighbors or the agent or anyone involved in these proceedings. And finally, if there's any additional variances that are required or any material increases in the relief that's required under the zoning bylaw, in that case, for minor variance applications, we would ask or we will require a recirculation of that application so that it is very clear what the application is all about. As part of the statutory public notice requirements, there needs to be a sign posted on the property for a prescribed amount of time before the hearing. And the way we deal with those things are through statutory declarations. Because of COVID, we have allowed another form, which is a sworn oaths or affirmations. We don't have any statutory declarations tonight, so we will do the oaths or affirmations for each application that we will be hearing. With respect to quorum, if we lose quorum due to technical issues or other, we would simply take the remaining items and put them on to the very next meeting of the committee. We, of course, will try and resolve our issues if they're technical before we'll go there, but you can be assured that those items are not lost. They're simply put on to the very next agenda. In terms of the hearing process, so you've seen that we have a very full agenda tonight. So we have a lot of applications that we're going to be needing to do housekeeping amendments to asking questions, getting input from the public. So there's a lot on for tonight. And what normally happens is we'll start with, in some cases, a fast track of an application where we're not going to require a presentation. And in some cases, we do ask for presentations. In either case, what happens after the presentation, or if there is no presentation, is the panel members are the first to have an opportunity to ask questions of the applicant, owner, agent, in order to get clarity around the application. If there's sometimes the application is fairly straightforward and we don't really need to ask any questions. Then we open it up to the public portion of the hearing. In some cases, I have a speakers list and some people are registered. If you're not registered, that doesn't mean that you can't address the committee. Of course, all you'll need to do is to raise your hand and the coordinators will bring you into the meeting and we will hear from you. In that case, though, because you may not be on the list already, we will ask you to provide your full name and your municipal address at the start so that it can form part of the record for the hearing on that particular application that's of concern. After that, the panel members may ask you some questions, maybe not, but they may ask you some clarification about your concerns. Once all of that is done, we will close the hearing portion of the public hearing portion of that application, and then the committee members get to deliberate. And sometimes it means making sure that some of the issues that were raised are then addressed by either the applicant or staff. So once all of that is done, we're at the decision point. So the committee then can, of course, grant an application, can refuse an application, can choose to adjourn an application if we feel that that would be helpful to everyone involved. And also we can reserve on an application, which means that there's a lot of new evidence that we need to further consider. And that means that after the whole of the hearing, the panel then stays back and has further discussion until we render a decision on that application. Once the committee has made all of those decisions, there is a formal written decision that is made available, and it is provided within 10 days of the hearing, and it provides also the reasoning for the decision, either whether it's an approval or a denial. And then all of those decisions of the committee are subject to a 20-day appeal period, during which time the decision can be appealed to the Ontario Land Tribunal for a fee. So with that, I'm done my opening remarks. I'm going to ask all of the members, is there anyone with a conflict of interest for any of the applications that are either before us as a panel tonight or before any of the other panels earlier today? Mr. White.
Madam Chair, as you know, there's an item that has been deferred a number of times. I think this is on our agenda tonight. I think it's item 13, Walkway Road. I previously declared interest on that, and that situation continues.
All right, thank you, Mr. White. Anyone else? All right, we don't have any minutes to approve this evening, but we do have a couple of adjournment requests. So I'm going to call those down first, and I'm looking for on applications 3 and 4 for 3663 Albion Road, looking for the agent who would be Ms. Dana Edwards or Ms. Christine McQuaig.
Good evening. It'll be myself, Christine McQuaig, speaking to the adjournment.
All right. Thank you, Ms. McQuaig. I think we know the reasons why we're looking at an adjournment on this, but do you have any words of explanation from your side and support?
We, through you, Ms. Chair, we have discussed the adjournment with staff. We do know that there's some additional desire from staff to find a design that is a better outcome with regards to tree retention. We have gone back and forth with staff quite extensively over the last couple of months, but we feel that there's some tweaks that can be done. So we're looking for an adjournment of actually not 2 weeks, just to give some additional time and level of comfort for staff to take their time to review. We are okay with adjourning to the hearing that would be after this one.
All right, so I believe that's October 6th. So I'd like to hear from Ms. Cully. Ms. Cully, I guess my question to you is, are you comfortable with, so I think October 6th is sort of a minimum. So my question to you is that still enough time, or do we need to go further out than that?
October 6th, through you, Madam Chair, October 6th would be enough time to review plans if they're submitted rather soon. I think what happened in this case is they were submitted later and later, and that's what resulted in the need for adjournment in this case.
All right, thank you very much. Any questions for Ms. McQuaig about this adjournment request? All right, I'm not seeing anybody. Anyone in the audience wants to speak either for or against this adjournment request on both the consent and the minor variance applications? All right, I'm not seeing anybody come forward, so the motion then is to adjourn this application, or to the both application consent and the minor variance, to the October 6th meeting. All of those in favor? All right, looks like it's unanimous. Ms. McQuaig, we'll see you in about a month.
Thank you very much. Have a good night.
Thank you. Okay, the next adjournment request is for number 7, which is 2250 Midway, and I believe I'm looking for the agent would be Mr. Ferguson. We have Mr. Ferguson. Do we have Mr. Ferguson? Okay. Okay, Mr. Ferguson, I see your name. Oh, great. Good evening.
There you go. All right, am I good now?
Yes, you are. You're good. So this
It's my first Zoom meeting, so
Oh,
my first
okay.
one. So,
All right. Well, it's really easy, actually. So if there's any issues, don't worry, Mr. Ferguson. We'll figure it out. So our understanding is that there is a need to adjourn this application,
yes,
as there is a survey plan that's missing.
yes, correct.
Okay.
We tried earlier in the spring. I was phoning all kinds of surveyors, and they were either booked up for the season, or they didn't get back to me, or they didn't want to come to Ottawa. So I sort of said, okay, with the price of wood, we'll put it on hold for a while, not realizing that this was going to be an issue at this point. And all of a sudden, what was it, a week and a half ago or 2 weeks ago, I come home from holidays and I was told I got to pick up a sign the next day. So that was kind of a surprise to me. So, yeah, so I'm going to need some more time to try to get a survey.
All right. So, Mr. Ferguson, we're going to propose that we adjourn the application sine die. All right.
Okay, yeah, and that's gonna, and is there a time limit on that?
No, there is no time limit. That's the good news. That's the benefit of doing a sine die, is that gives you a lot more time to find a surveyor and a surveyor that you want, so it doesn't rush you.
Okay, and the bad news is it's going to cost me to open it up again. So,
well, there's a recirculation fee, but I think that at the end of the day, it's not substantial in comparison.
Okay, all right.
All right, so I'm just going to open it up. Oh,
I was just wondering, in the survey plan itself, what particulars are you actually looking for? Do you need the 4 corners, and what else? Or
I am going to refer you to go back to committee staff tomorrow, give them a call.
Committee staff,
and they'll be able to provide you with far more guidance than I would, and I would in fact, I probably would mislead you, so you're far better off going back to committee staff.
All right.
And so I'm just going to ask the committee members, anyone want to speak to this adjournment proposal to sine die? Not seeing anything. Do need to call on the public. Is there anyone in the audience who wants to speak either for or against this adjournment sine die? Not seeing anyone. All right. So members, I need a vote. All those in favor of the adjournment. All right. So I think I've got 4 approving and 1 dissent. Is that right, Mr. Hindall? Mr. Hindall? Oh, maybe we've lost.
No, I'm good.
Sorry, Mr. Hindle, we still haven't caught what you said there and you're frozen. Okay. Are you dissenting? Or
there we go. No, I'm good.
Okay. All right. So Everyone's in favor then, for the record, of adjourning this application sine die. So Mr. Ferguson, we're going to wish you good luck and look forward to seeing you in the not so distant future.
Okay, and whenever I'm ready, I just call the Committee of Adjustment again, get in contact with them, and
Absolutely. We can, yeah, that's your contact for sure.
okay, perfect. Thank you very much.
All right. Thank you. Have a nice
Thanks,
evening.
everybody. Have a good night.
Okay, thank you. All right. So we're on to our regular list of applications. And I think we're just going to go in order. We have a number of fast tracks this evening, given the volume of applications that we have. So the first one I'd like to call down is, applications 1 and 2, which is 207, 209 Carillon. I believe I'm looking for Mr. Chan and Mr. West. Good evening, gentlemen.
Good evening, Madam Chair.
So I do need to read something to you. Who's taking the oath or affirmation?
I will.
All right, Mr. West, do you solemnly swear or affirm that the notice provided to you as part of the application process and by the committee was posted on the property to which the application applies for the prescribed amount of time prior to the hearing, and that the sign was clearly visible and legible for the entirety of that time? Do you either swear or affirm that to be true?
I swear.
All right, thank you. Okay, and I guess the next thing we need to do is, my understanding is we have a few housekeeping amendments on this report. I'm going to ask Ms. Ramirez to come forward, because I guess there's been a lot of last minute changes, and I just want to be absolutely clear about what's before us. So Ms. Ramirez, I did notice that in the revised comments, we were doing a number of different things. So instead of deleting variance C, we're actually going to reword it. And I also noticed that there's been the elimination of one of the conditions, which related to demolition. Is that correct?
Yes, Madam Chair, that is correct.
All right, well, I'll come back to the conditions, but for the moment, I'm going to read for the record what the changes are that are proposed. Mr. West, you're aware that staff have proposed an amendment to variance C?
Yes, we're aware.
All right, so I'm going to read it into the record. To permit a reduced front yard landscaping area of 0 of the front yard, in this case, 0 square meters, whereas the bylaw requires a minimum of 20% of the required front yard area to be landscaped. In this case, all lands within the front yard that are not occupied by permitted driveways, walkways, and projections must consist of soft landscaping. Is that correct?
Madam Chair, if I may step in, that's not what we have in front of us. You had more words than we have in front of us now.
All right,
What
Ms. Ramirez.
we have, and it's, I believe it's in the red line version of the report prepared by Ms. Ramirez dated August the 31st, or what I have in front of me, which actually is, an amendment that we requested, is that variance C would read, quote, to permit a reduced front yard landscape area of 0% of the front yard, in this case, 0 square meters, whereas the bylaw requires all lands within the front yard that are not occupied by permitted driveways, walkways, and projections must consist of soft landscaping.
All right, it could be, to be honest with you, I took what was in the red line and I added it to the original report, so I might have missed something there. Ms. Ramirez, can you confirm that to be the correct rewording?
That is correct.
All right, thank you, Mr. Chan, for catching that, because I didn't see that when I transcribed. So, okay, good. All right, any other changes? I'm not seeing anything else that's required from a housekeeping standpoint. All right, in terms of the elimination of the demolition conditions, so instead of 8, we seem to have 7. Can you tell us, Ms. Ramirez, why we're looking at why that's been deleted, essentially?
Thank you, Madam Chair. There was a condition related to, there's an accessory structure that's straddling the proposed severance line on 211 Clarion Street. And the applicant has asked for that to be removed, and in conversations with senior staff, we've agreed that removing that accessory structure can be left up to the property owners of 211 and the owner of 209.
Madam Chair, I want to clarify, the structure that we're talking about does not straddle the proposed severance line. It sits on the existing lot line on the, I think it's the east side of the Carillon property. It's actually an accessory structure for the neighbor next door, which is encroaching on the property, but it is not sitting on the severance line. So it's simply a matter between our client and the neighbor next door if they want to get them to move that accessory structure, but it is not sitting on the proposed severance line. And we can show that to you. We can show that to you on the survey plan if necessary when Mr. West gets into his presentation.
So that explanation is fine. So I just needed to understand why that demolition condition was being removed. The only other change that I can see, and I guess Mr. Ramirez, I'm looking for you to confirm again, is actually new condition number 6 with regards to joint use, maintenance, and common elements agreement. First paragraph, I have at the end of the sentence, new wording, which reads, for the access easement over part 3 in favor of part 1. Is that correct?
That is correct.
All right, Mr. Chow, Mr. West, you're in agreement?
With condition 6 as amended, yes, we are.
All right, perfect. I think that is the end of the housekeeping amendments. We're not going to require a presentation this evening from you, Mr. West. I believe, though, that committee members do have questions for clarification.
And Madam Chair, if I may, we will have comments on some of the other conditions.
Yes, we did see some correspondence earlier, Mr. Chan, on that. I'd like to just get the questions and clarifications out, and then we can get to the conditions. So, Mr. White, the floor is yours.
Madam Chair, if I could just get some clarification on the minor variances with respect to the reduced front yard setback. I noticed that the application includes a reference to 2 minor variances with respect to the front yard setback, A and B. And I wonder if I could get an explanation of the need for the 2 minor variances there, A and B. They seem to be, they're dealing with the same 0.9 meter setback, but they're separated. Can I get some explanation of something to do, obviously, with the wording of the bylaw?
I have to admit, I kind of got caught on it myself, but I think I figured it out. But I'm going to ask Mr. Chown or Mr. West to provide that overview.
I will defer to Mr. West on this one. Thank you.
All right.
Thank you. So I'm trying to find the exact reference in the zoning bylaw on the fly, but essentially the requirement for front yard setback is mentioned in 2 different places in the zoning bylaw, and we're seeking the relief in the abundance of caution.
The provisions as quoted in the variances are different. One requires a minimum and the other establishes what appears to be, well, I'm sorry, I'm misreading this. Maybe Ms. Ramirez can help, but I do appreciate Mr. West's comment that there are 2 separate provisions that we're dealing with. If we were to go to our original application, it would refer to the sections of the bylaw that we were seeking relief from.
All right, Ms. Ramirez, did you want to take a stab at explaining the difference?
Yes, Madam Chair. The provisions in the bylaw are written that it be the average of the abutting owner's property, and that in no case may it be less than 1.5. So it is out of an abundance of caution that the owner is requesting that it be 0.96, which is less than 1.5.
All right, thank you. That's perfect. Mr. White, any other questions?
No, thank you, Madam Chair. It's very confusing, and I'm not sure I still understand. I understand it, but it's not a significant variance, so I don't have a problem with it.
All right. Any other questions? Ms. Willis?
Just a question for the applicant. I'm a bit confused as to how, just looking at the pictures of the existing dwelling that's to be converted, how it got constructed with all these setback variances that would otherwise be required. Is that a change in the bylaw since the house was built, or what happened?
Well, through the chair, I think planning staff actually have explained this quite well, that they, in their report, they indicate that the original building, I think, was built in 1951, which predated any zoning bylaw in the city or in Vanier at the time. And there's just been a series of renovations, additions to that structure since then. So there was no zoning in the first place. And so we now have what is a legally non-conforming structure, and we're simply trying to regularize all of those inconsistencies with the zoning bylaw today so that we have no issues when we go for our building permit for the conversion.
So would the conversion require the variances, or you're still residential? So would that be a requirement, or is it just, as you say, in the abundance of caution?
I'll be perfectly frank. We've had a great deal of difficulty with interpretations of the zoning bylaw at the building permit stage. And in particular, when we're relying on legal non-conforming rights, where if for any reason the review officer in building code services questions whether or not we have legal non-conforming rights, we either have to then come back to the committee for minor variances, or we have to go through a different process with the city to try to demonstrate legal non-conforming rights. We're just simply trying to smooth the path so that we can get a building permit for the conversion.
Thank you.
Questions? I'm just going to ask one sort of related to Ms. Willis's question. So the structure itself today, where it is as a single dwelling unit, is already would require, if you were to build it today on a vacant lot in the same way, you would need the variance. You would need some variances, but that the variances that you've requested are actually specifically for duplexes.
They're specific for the duplex, but I think that I would be corrected, or somebody would point out that the provisions for the duplex and a detached dwelling in the zoning bylaw are actually the same.
Okay, all right, that's quite possible. Okay. All right, now let's see if I have anybody on my speakers list. I don't have anyone on my speakers list. So I'm going to call the audience out on whether or not anyone wants to address the committee. So if you have any concerns or you want to support the application, now's your chance. You can just raise your hand and come forward. Okay, I'm not seeing anybody come forward at all on this. All right, with that then, Mr. Chow, before we go to a vote, let's talk about those conditions that you would like to either amend or remove.
So, Madam Chair, let me start by saying that we have no concern with conditions 2, 4, 5, 6 as amended, and 7. I just want to speak about conditions 1 and 3. And actually, given the questioning from yourself and Ms. Willis, I'd like to start with condition number 3. Condition number 3 requires our clients to demonstrate to the satisfaction of the city that the existing dwelling on Hannah has been converted from a detached dwelling to a duplex dwelling under the authority of a building permit. I can tell you that our clients had every intention of converting that building to a duplex many, many, many months ago. They filed a building permit for that for a conversion. Unfortunately, the designer characterized that application, rather than converting to a duplex, as a request to add a secondary dwelling unit to the single detached dwelling. But despite that, Building Code Services came back to our client at that time and said, sorry, we can't give you a building permit because we have that other detached dwelling on the lot, the existing dwelling facing Carillon. There was a discussion, it's not documented in writing, but there were phone calls and there may actually have been emails between my client and the designer and Building Code Services last spring. Said, well, sorry, we want to convert it to a duplex. And they were advised, doesn't matter, we're still not going to give you a building permit until you actually sever off that structure so that the two properties are separate and the two buildings are separate. Planning staff have indicated to us yesterday, there was all sorts of back and forth on this file yesterday, indicated to us that no, if you consider that building on Carillon as a coach house, then you can get a building permit to convert the existing building to a duplex. But I just don't want to take that chance. I don't want to take the chance that we're going to go back to Building Code Services, say, okay, please give us a building permit for the duplex before we complete the severance. I don't want Building Code Services to say the same thing now that they said in March, which is no can do. And so we don't believe it's appropriate to impose condition number 3. Quite frankly, I don't know what it accomplishes. But we have our clients have a plan. They want to convert that building to a duplex. They know they need a building permit. They have an active building permit file with Building Code Services. They need to amend that application before they're going to get a building permit. But it'll be a whole lot cleaner for everybody if we get the severance first and then get the building permit, as opposed to what this condition is saying. Not only do we need to get the building permit, we actually need to do the work before we can clear the condition. I have no idea why Building Code Services is asking for this in the first place. There's a process to go through to get a building permit. We're trying to smooth the way to get that building permit, including severing off the existing house on Hannah from the house on Carillon. And
So, Mr. Chan, I think you've explained it really well. But I do know that the staff had a bit of a different position on this. So, Ms. Ramirez, I'm going to give you a chance to explain why you would like it retained.
Thank you, Madam Chair. A building permit is required to alter the detached dwelling to a duplex. Per the notice that was submitted, the building is to be converted. So we've asked for that building permit. I can talk about condition 1 now, or we can leave it for when.
Let's not talk about that one quite yet. I want a decision on whether we're retaining or we're deleting the condition number 3. So I'm going to put a motion forward that we delete condition number 3. All those in favor for that? It's not an official vote, but
just ask a question of staff about
Sure.
this. Ms. Ramirez, I'm just curious about why the committee would have any concern whatsoever about whether it's a single or a duplex.
Through you, Madam Chair, both are permitted. I'm just following the notice that said that it was going to be converted to a duplex. So staff has imposed a condition per the notice that was circulated.
But if we take that condition out, it's really, I consider that background information that the existing dwelling is being converted to a duplex to explain why they're going through the variances at this point in time, as opposed to making it an absolute requirement that it go through as a duplex. So I personally don't say, I put, why do we care on the condition? And I think I would agree. I'm sorry, I just wanted clarification on that. So thank you.
all right, thanks. I'm going to go back. Any other questions before I try to get a vote on the removal of condition number 3? All right, all those in favor, please. I need to see who supports that. All right, so it's pretty unanimous. We're going to delete condition number 3. Mr. Chown, let's go to number 1.
Thank you very much, Madam Chair and members of the committee for that. So condition 1 requires demolition of the existing house on Carillon. I've only seen in 30 years of experience in consulting, I only see this condition requiring demolition of a structure as a condition of a consent application when that structure straddles the future property line. Makes imminent sense. We don't want to be creating new lots with a severance line through a building, so the committee imposes a condition requiring demolition. Why, to use Member Willis's comments, why the committee would require demolition of the existing house on Carillon as a condition of the severances, once again, with respect, is beyond me. You know, that house, that existing house will come down when the property redevelops, but why it has to come down before we finalize the severance is beyond me, because it's not straddling a property line. It'll come down in due course. Our clients will go through the proper process under the Building Code Act in terms of a demolition permit and in terms of a building permit. But whether that building is there or not doesn't relate to the severance application that's before you this evening. It can still remain while our clients work on the existing building. They'll come back later and do, you know, they may do this in stages. They're not going to do it all at once. And why would they demolish the existing building any sooner than they have to? And so, as I say, I'm used to seeing this condition time and time and time again, where there's a building straddling the severance line, but that's not the case here. So I don't know why it's being requested. I know we've put this question to Ms. Ramirez, and I'll leave it to her to respond. But you know, if it's simply because the notice says it's going to be demolished, I don't think the committee's in the habit of imposing conditions that say notice says this, therefore to clear your consent, you have to do this. It's
Mr. Chan, I can
never in my experience.
So I have seen situations in the past where it's a single family dwelling. They want to build a semi-detached or a duplex, and I've seen that condition imposed about the capping of the services and the demonstrating that it's been demolished. So I've seen this before where it wasn't a lot line straddle. So I'm not that fussed about, you know, trying to ask for something that hasn't been done in the past, but I want to hear from the other members of the committee. I see Mr. White has his hand up, so please go ahead.
Thank you, Madam Chair. Question with respect to the retention of that of the existing dwelling. I'm assuming that if the dwelling is retained, that the minor variances that are applied for, and if presumably if they're approved, would cover all of the requirements, deficiencies with respect to that dwelling. So in other words, you'd have a building on a new lot that would conform to the variances that would be granted that are being proposed here. Is that correct?
If I can help, the condition isn't clear, but the condition I'm understanding is for the demolition of the small house on Carillon. All of the variances with respect to interior side yards, front yards, and whatever is with respect to the building facing Hannah, which is will remain and will be converted. So all of those variants relate to the building that's to remain. This condition relates to the building that's to be demolished.
So, but with the severance of the property, would both buildings conform to the bylaw requirements or the variances that are being asked to be granted here? Because I can understand the situation, the interest in getting a demolition done if if that particular dwelling that's going to remain doesn't conform to bylaw requirements, because you're changing the lot fabric situation.
I follow now, Member White, and thank you for that. So we didn't seek any relief in terms of variances for the building to come down. It's currently legally non-conforming, but we didn't seek any relief in terms of all of its non-conformities because we don't intend to keep the building. And so we know it's going to come down. So it's non-conforming today. It's going to still be non-conforming after the severance.
But it will be non-conforming in a different lotting situation. That's
Right. And so, and the difference would be, we have asked for a minor variance in lot area for that property, which is the only change to the existing condition, will be the reduced lot area. So you have that variance in front of you to reduce the lot area for that new lot that we're creating where that existing dwelling sits that will be demolished.
All right.
Madam Chair,
So-
maybe where we need some input from staff on the.
Absolutely. I was going there, Ms. Ramirez.
Thank you, Madam Chair. The building that is on Heron is set closer to the front lot line, and it also has a driveway that leads to parking at the back of the building for the building on Hannah. And so demolishing that building, the new building doesn't plan on having parking. It has an access easement for the benefit of the property on Hannah, but it doesn't have any parking on site. And that's part of the reason that staff is all right with a minor variance on the Heron property, because the new proposed building doesn't have any parking.
All right. Okay, thank you. Any further questions from the committee before we determine what we want to do with condition number 1? All right, so I'm going to propose all those who would be in favor of deleting condition number 1. Okay, I'm going to dissent on that, but as you know, it's a majority rule. So in that case, we are going to delete condition number 1 as well. Okay, Mr. Chown, are we done with the conditions?
I'm done. I'll let you get on with your evening after you do all your final formalities here. Thank you very much.
Well, thank you. All right, members, I think we need to.
Excuse me, Madam Chair. We just received a speaker for this application. Lori Gillis from 208 Carillon.
Okay, that wasn't on my list, but all right. So, sorry, the name again, Ms. Williams? Ms.
Right,
Williams?
Lori Gillis.
Lori Gillis. All right. Ms. Gillis?
Hi, the address is 208 Hannah, not Carillon.
208 Hannah. All right, thank you for that. Okay, go ahead, please.
It's my first time participating in such a committee, so I don't know anything about your protocols. The list that I got of the changes does not match the ones that you guys are discussing verbally. So the list I have has A, B, C, D, A to G, not 1 to 7 in terms of changes.
Oh, okay, so there's 2 different things going on here then, Ms. Gillis. So what you are looking at, the ABC, those are in reference to the minor variances themselves, whereas what we were discussing is the conditions that would be imposed on any consent approval.
Okay, are those in the letters that were issued to homeowners?
Those conditions are part of the staff's report. So once the staff has had an opportunity to review the proposal, so this would be after the notices get circulated,
Okay.
staff has an opportunity to analyze what's being proposed, and then to recommend anything that would be in either the city's interests, the applicant's interests, or anyone else's, any other technical agency's interests. That's what the conditions are for. Some are very standard, and sometimes we have some particular ones that are essentially to facilitate and enable the development of a particular proposal.
So the condition you guys just voted on is to remove the condition that the duplex application have to go hand in hand with destroying the coach house? Is that what I understand?
So what we're suggesting is that, yes, in fact, there is no requirement as part of the approval of the consent that particular structure be demolished. I think what the applicant is saying is that it will be in due course because the intent is to redevelop the site. And so for that reason, at this point in time, I think there's reasonable assurances that the demolition will occur, that it need not form part of a condition.
But it doesn't have to occur in the future.
We are not exactly, there's nothing about what our approval is doing that will compel them to do it.
Right.
So can you?
Madam Chair, I
are
can
you-
reassure the speaker that it is going to be demolished. It's just a question of when.
All right, so I think I'd like to go back to Ms. Gillis. And so what are your concerns then about either the consent or the minor variance application?
Madam Chair, we can't hear you.
No.
How is it that you can't hear me? So can you hear me now?
Yeah.
Okay, good. All right, so Ms. Gillis, what I'm really looking for then is some comments from you, whether in support or in opposition to the consent applications or the minor variances that are being proposed.
I don't know what consent application means. I have comments on the minor variances. Is that what you're asking?
Yes, there's two applications before us right now. There is an application to subdivide the land so that the parcel that fronts on Carillon is separated from the parcel that fronts on Hannah. And the second part of the applications to allow the proposal is for the minor variances. So if you have comments on the minor variances, please go ahead.
I just wonder whether severing the two things would it still be possible to sever the two things if the coach house was right beside the duplex? Or is it because it's around the corner with another building beside it? My concern is other properties in the neighborhood where there's a duplex with a garage that can be converted to a coach house being severed and then ending up with two duplexes. I have reasons to be very concerned about this precedence of severing the coach house from the property.
So it's not really about severing the coach house from the remainder of the property. It's actually more about whether or not the consent application constitutes good planning given the proposal that's before us. Each application, there is no precedence from the committee's standpoint. Our job is to assess every application that's before us on the basis of the 4 tests under the Planning Act.
There's no precedent.
No, the committee is mandated to consider each application on its own merits and in relation to the 4 tests under the Planning Act for minor variances.
Okay, well, that's not what the news reports, and it's not what developers looking at Vanier think when they're planning what to do with the duplexes and the old houses. But okay.
So Ms. Gillis, I mean, what I think I'm hearing is that you have concerns, generally speaking, about some of what's going on in your neighborhood in Vanier. What I recommend to everyone is to approach your community association and to get involved with them to understand so the community association is supposed to be part of ensuring that residents in the neighborhood are aware of what's being proposed from a development standpoint, not just from our jurisdiction, but any development proposal under the Planning Act. So what I'm going to recommend is that you get a hold of that organization. And if you'd like some help with that, I'm sure committee
Oh, it's
staff.
fine. I'm familiar with them.
Okay, all right.
They're not familiar with these types of proceedings. That's for sure. I don't agree with getting rid of green space, especially in this neighborhood where it's all concrete and we need more greenery. So there's to me, a real problem that we have buildings being approved to go right up to the sidewalk, which is, I guess, called reducing yard setback in committee speak, because we actually need more greenery. There's barely any space. There's like a, I don't know, 1.5 foot space between the sidewalk and that coach house, so-called coach house. And it should stay green space. That is. And
Thank
stuff
you,
should be
Ms. Gillis.
planted.
We have to deal with the application the way it's before us today and the relief that's being sought. I don't see, Ms. Ramirez, you can correct me, but I don't see any concerns with regards to our forestry services.
I'm talking about the front yard landscaped area to 0%.
All right, Ms. Ramirez, can you please provide some insight with regards to them?
Yes, staff actually indicated some concerns with the variance to the soft landscaping, because if it's indeed legal non-conforming, then it's not necessary, and it's not something, reducing the soft landscaping is not something that we want to encourage. And if it's not legal non-conforming, then staff's preference would be to have it be soft landscaping. So staff's preference is actually to delete that minor variance.
To delete which minor variance then?
The soft landscaping one.
All right, let me catch up here. Which one are we talking about specifically?
Madam Chair, that's variance C that we spoke about at the beginning of this meeting.
Yeah, exactly. I'm seeing that here now. And so it's all right. So the idea would be rather to give any relief from that in fact it be eliminated completely. Need comments from the committee, looking for your input on that, Ms. Willis?
Just a bit confused. The variance with regard to the front yard and the landscaping pertains to the existing building. And the coach home, as it's being called, is over on the other street, and there's nothing that is being proposed at this point in time. So they will either have to adhere when they demolish that house with the zoning bylaw at the time, or come back to this committee if they want to have reduced front yards and that sort of thing. So I don't see that we're doing anything here that lessens the green space in the area, since what we're doing is just confirming an existing condition and nothing with regard to the future rebuild on the other street.
I think you're completely right, Ms. Willis, because that C actually only applies to the property fronting on Hannah.
Yeah.
Okay, all right. So in which case, anything that's built on the Carillon frontage does not have relief from the bylaw with regards to the landscaping requirements. Is that correct, Ms. Ramirez?
That is correct.
Okay. All right. Ms. Gillis, did you follow that discussion? All right, I think we may have lost her. Okay. All right. Anyone else? I think we actually kind of closed the public portion, but willing to hear from anybody else? Right, not seeing anyone. I think we're ready to go to a vote at this particular point in time. I think we've, Mr. Hindle.
Yeah, Madam Chair, I think in this case, I would be inclined to be aligned with staff on this. I think I'm ready to approve the variances with the exception of C. I tend to agree that it's legal non-conforming, so it can continue, but if there was ever redevelopment in the future, I prefer that it be greened over time.
All right, okay, thank you. Other thoughts from the panel? Okay, then I'm gonna call a vote.
Can't hear.
As I'm gonna call a vote. Not sure why. It must be something to do with what's going on in the building. So I'm gonna call a vote on, I think, variance C. So we have variance C that amends what the requirement is, which is to lessen it though, so it provides relief. So there's a proposal now, based on the discussion that we've had, that in fact we would delete variance C altogether, as was originally proposed by staff, thereby ensuring that legal non-conforming rights, great. If you do anything in the future, however, in terms of, say the conversion doesn't happen and we decide to do something else, that particular variance has not been granted. So in other words, if they come back and say they decide they don't want to go ahead with the conversion, and they decide 2 years, 3 years from now, what they really want is a triplex. But in the meantime, we've granted a minor variance to what I think is an existing building. So I guess that there's a chance that they could use that variance to their advantage in the future. Mr. White.
Madam Chair, my understanding is that minor variance is with respect to the existing situation. And if the existing situation no longer exists, am I incorrect in assuming that the established rules will apply? In other words, compliance with the zoning bylaw would be required? Am I wrong there?
Yeah, you're right. I think if we tie it to plans, strictly to plans, and something happens to the footprint of that building that changes, it might be. All right, okay, so maybe there isn't an issue with regards to redevelopment. Mr. Chan?
I was similarly going to say, if you tie that variance to the life of the existing building, we'd be fine.
Okay, how about we do that? Then, Mr. Hindle, does that provide any comfort?
I think that works.
Okay, I'm looking for some guidance from staff in terms of how we might further vary condition C, because I think, so either we can tie it to condition C, or when we give our approval, if that's in fact what we do here, then it will be tied strictly to plans and the life of the existing building fronting on Hannah.
So, Madam Chair, just to confirm, the conversion of it to a duplex will not change the footprint of the building. Just asking Mr. Chown for clarification on that to ensure there's no, or it wouldn't be interpreted that the building is being changed in substantial a manner that it would no longer apply. The variance would no longer apply.
There is no change to the footprint of the existing building.
Okay.
Okay. All right. I think what I'm hearing then is, I guess I need to vote. Are we deleting amendment, or sorry, minor variance C? So all those that would be in favor of doing that, again, I just want to see a show of hands once again.
Madam Chair, I'm not clear. So what's the alternative? Is to keep it in, but to tie it to the plans? Those are the two options?
Or we not put it in and we tie it strictly to the life of the buildings, to the plans and to the life of the buildings on the plans as they are today.
But that means we keep it in,
only
right?
be actually, it could only be tied to Hannah, right? Not Carillon.
But if we tie it to the plans, we keep it in. We keep in condition C, right? Yes, so we keep it in, but tie it to plans.
All right, all right. So you don't have to though, because the idea is, say we don't have that minor variance there. Reality is, I guess what we're saying is, because the approval is tied to strictly to the proposal and to the life of the existing building. If they were to try and change that in the future, then they'll have lost. They would have to come back if they didn't want to meet. Like they would have to meet the requirement under the zoning bylaw or come back to the committee.
Mm-hmm.
That's without C. So in other words, deletion of C does not put us in a position that
their concern is that at the building permit stage that it might be construed that they don't have non-conforming rights and that conversion could result in them. I think I'm putting words in your mouths, but I think that's what their concern was. But it may be interpreted differently, and they wanted to clarify the whole thing. So I think it's fine to keep the condition in, but to tie it to the existing plan or the existing life of the existing building in question.
All right, Mr. Chown, I'm surprised you didn't jump in there. I was kind of surprised.
No, I think we're going down the right path, and it's not to muddy the water. Quite frankly, all of the variances with respect to the building on Hannah should probably be tied to the life of the building.
Mm-hmm.
Including the front yard setback.
All right, I see Ms. Ramirez has her hand up. Ms. Ramirez.
Yes, just to reiterate that staff's position is that the variance C for soft landscaping is not needed because it has the building, if the building enjoys legal non-conforming rights, then that variance is not needed. If the building does not enjoy that hard landscaping benefit in the front yard, then staff's preference is to see it become soft landscaping.
But I want to be clear, all of the variances we are seeking are to regularize the non-conforming conditions for that building, including the landscaping in the front yard. We believe we got
Mr.
legal
Chair.
non-conforming rights to all of those things. We're looking for minor variances to regularize those variances. Feel free to tie them to the life of the building.
Mr. Chairman, that's what I'm inclined to do at this point, is to retain variance C as amended and to simply tie it to strictly to the life of the building on fronting on Hannah
Correct.
specifically. All right, Mr. White, have you got something you want to add?
Yeah, and Mr. Chown can correct me if I'm wrong, but I think he's got some uncertainty with respect to how Building Code Services is going to react to a building permit application. I fully understand where he's coming from, and I would suggest that our approval of variance C is highly appropriate in this situation.
All right, okay, folks, I think it's decision time for both applications. So on the consent application, all those in favor? All right, I think for the record, the consent application is unanimously approved. And on the minor variances, all those in favor? All right, so I'm going to approve it. So we've got one dissent from Mr. Hindle.
Yeah, I think, Madam Chair, I'll just dissent on variance C. I think the rest I'm perfectly fine with approving.
All right, thank you, Mr. Hindle. And those, of course, these approvals, of course, are as amended through our discussion today with regards to the wording, the removal of the conditions that we talked about, and we're tying the plans, the approvals, sorry, of the minor variances to the life of the building, specifically at 207 Cavium. All right. And okay, I don't think there's anything else. We've gone through the conditions.
Just to be clear, to the dwelling on Hannah, not the dwelling on Carillon.
Oh, sorry. Yes, of course. 209 Hannah. Okay. I think we're done. I think we're good. But
thank you, Madam
both.
Chair. Thank you, members. Appreciate your time.
All right. Thank you.
Have a
nice
good evening.
Okay, we're on to application number 5, looking for, and that would be 321 Cloverdale. Looking for, who am I looking for here? Okay. Forgive me, I'm not sure who the agent is on this application. For number 5, Mr. Michelle McKenna.
I am Christopher Simmons.
Oh, Mr. Simmons, sorry about that. Somehow I lost the front page of my cheat sheets.
Michelle McKenna is also here. If there's any skill testing questions, she'll likely have to answer them.
Okay, all right, we'll save those for her then for sure. All right, Mr. Simmons or Ms. McKenna, who's going to take the oath or affirmation?
Madam Chair, I can take the oath. I posted the sign. Yeah.
All right, thank you. So do you solemnly swear or affirm that the notice provided to you as part of the application process and by the committee was posted first at the property to which the application applies for the prescribed number of days before the hearing, and that the sign was clearly visible and legible for the entirety of that time? Do you either swear that to be true or affirm that to be true?
Yes, I do.
You affirm?
Yes.
All right, thank you. Okay, we don't need to have a presentation for this application, and I don't see any housekeeping amendments required either. So with that, then I think I can open it up directly to questions from the panel. Anyone? Any questions? I think it's a fairly straightforward application. We've had a chance to review all of the plans. With that, then I am going to open it up to the public. I don't believe I have anybody to speak to this application. So is there anyone in the audience who wants to either speak for or against this application for a minor variance? Not seeing anybody come forward. Okay. Well, I think that was pretty short. Committee members, I think we're ready to make a decision then. All those in favor of the application? All right, for the record, the application is unanimously granted. Thank you very much for your time this evening.
Madam Chair, thanks very much.
All right. Bye now. Okay, we're on to application number 6 then. I'm looking for Mr. Hume on this application. Good evening.
Good evening, Madam Chair.
I am going to read to you, as always. Do you solemnly swear or affirm that the notice provided to you as part of the application process and by the committee was posted on the property to which the application applies for the prescribed number of days prior to the hearing, and that the sign was clearly visible and legible for the entirety of that time? Do you either swear or affirm that to be true?
I swear that to be true, Madam Chair.
All right, thank you, Mr. Hume. The panel has had a chance to go through this application in detail and will not require a presentation as a result of that. So, and we are aware that you already have approval on your zoning bylaw amendment for this. So committee members, any questions for Mr. Hume about the proposal? No? All right, I don't have anybody on my speakers list for this application. So I'm going to put it out. Is there anyone in the audience who would like to speak to the committee, either in favor or in opposition to this application? Now's your chance. All you need to do is raise your hand and come forward. All right, I'm not seeing anybody. So I think before we go to a vote, Mr. Hume, do you have any concerns with regards to the conditions?
No, Madam Chair. I've reviewed the conditions, and I don't like entering into development agreements with the city because the only reason is they take so long, but we're prepared. We've got pre-approval. We can meet the conditions.
All right, thank you, Mr. Hume. Okay, then without further delay, all those in favor of the application for consent? All right, for the record, the application is unanimously granted. Mr. Hume, I believe we have you on a little bit later this evening, so we won't say goodbye yet.
See you later then, Madam Chair. Thank you.
All right, thank you. Okay, application number 8 is 48 Glen Manor Drive. Looking for Ms. Daou and Mr. Thierot.
Good evening, Madam Chair, members of the committee.
Good evening. All right, so before we get there, gotta read to you, Ms. Daou. Do you solemnly swear or affirm that the notice provided to you as part of the application process and by the committee was first posted on the property to which the application applies, was posted for the prescribed number of days prior to the hearing, and that it was clearly visible and legible for the entirety of that time? Do you either swear or affirm that to be true?
I affirm.
All right, thank you. Many housekeeping amendments to the notice. So my understanding is we have a revised plan, and because we have a revised plan, we have in fact less relief to be reflected as part of the notice. So I'm going to go through these and then I'll need you to confirm. So 2, minor variance A, it will read to permit a rear yard setback of 18.8%. We're striking 16.65. The lot depth or 5.75 meters, and we're striking 5.03. Is that correct?
That's correct, yes.
All right, B, to permit a reduced rear yard area of 18.8%, and we're striking 17% of the lot area, in this case, 131.46 square meters, which I believe we're adding. Whereas the bylaw requires a minimum required rear yard area of 25% of the lot, in this case, 174.48 rather than 175.56 square meters. Is that correct?
That's correct as well, yes.
All right. I don't see any other housekeeping amendments with all of this. We will not ask you for a presentation, but I am going to throw out to the panel members the opportunity at this point to ask some questions. All right, Mr. Hindle, I don't see you, so I'm not sure if you have no questions, Mr. Hindle?
No, I'm good, thank you.
Okay. I do have, I believe, somebody, a few people on my speakers list. And before I go there, maybe Ms. Dow, you can tell me a little bit about the consultation that occurred with neighbors prior to your presentation of this proposal to us.
So my understanding was that the owners had approached the neighbors, anyone that was willing and available to speak with them. I personally did not approach. This was sort of in the height of the pandemic closures, but I was informed that they had approached their neighbors, anyone who was willing to discuss. We had also notified the counselor's office before submission of the application. We did also request that they pass that information along to any relevant community association members. I wasn't able to track down through the city's website any contacts for the community association. So I did ask that they pass that along or provide me with contact information. And unfortunately, I did not hear back anything. So that was the extent of the consultation.
All right. Okay. When you say that the applicant approached, what do you mean by that? Was it email? Was it knocking on doors? Was it?
The applicant is actually, I believe, on the call. So perhaps, not to put them on the spot, but perhaps they want to touch on that. But I believe that they have a fairly, from what I understood, a fairly good relationship with their neighbors and are friends with a lot of them. So they were discussing with those ones. And further to that, perhaps Nicole could address the discussion.
Yep, it was basically a conversation had with our three neighbors.
Excuse me. Whoa. So if we're gonna, I need to identify you for the record, okay? Because we have to be really clear about who's addressing us. So just for the record, your name is Nicole Dunlop. And can you give me a municipal address, please?
Yep, 48 Glen Manor.
All right. Okay, so you're actually the resident there today. Okay, perfect. Now, if you could just confirm what you did with regards to consulting with your neighbors.
We have 3 direct neighbors, and so we had direct conversations with all 3. 2 of them, there were no concerns and there were no issues. The other neighbor, I think, has submitted a letter to you. That conversation, unfortunately, wasn't fantastic, and so there has been no further conversations with them.
All right. With that, then, I'm going to go to the public hearing on this application. I do have 3 names, all at 50 Glen Manor. So Mr. Young, Mr. Richard Young, Mrs. Geraldine Young, and Ms. Karen Keeley. I need to know who's going to speak.
Our daughter is speaking on our behalf. Her name is Karen Keithley. And
all right, okay.
I dispute that we see them every day and they have not approached us.
All right, thank you. So Ms. Keithley?
Yes, good afternoon.
The floor is yours. So you typically we give 5 minutes for residents. So please proceed.
Okay, perfect. Good evening, Madam Chair. As the adjacent property owners to 48 Glen Manor Drive, we want to ensure that the 2 clearances associated with the hydro pole with transformer are not forgotten or lost during the process. As you may know from the written submission, that there was several things that were discrepancies between the site plan. And being that we are the adjacent neighbor, it was noted right away. So for us, certainly the hydro pole with the clearances is of concern because it's a health and safety issue. The clearance, it does fall over onto 50 Glen Manor. I did personally contact Hydro Ottawa, which my understanding is that you have a written email from them as well concerning the hydro pole and the clearances that are required. I'm not an expert in this area, but our concern was that by shortening or the depth of the rear yard setback, that it may not be enough in order to properly house these clearances. And that was our concern. Again, my parents had indicated that they had not been approached to see any plans or anything. We have also contacted the Crestview Meadowlands Community Association. You'll see that that's in our submission as well. I have had several conversations and with Greg Elliott, who is the president of the Crestview Meadowlands Community Association. He has advised me that he had not been contacted or was aware of this minor variance application. And so he did as you see in the written submission, he did review this written submission and does support it.
It was not noted on the, I'm sorry, Madam Chairman, but it was not noted, the hydro pole and transformer was not noted on the site plan. It was omitted. And therefore the hydro has contacted the City of Ottawa stating that, they should have been contacted about this.
Any other issues?
There is several other things that we did note that were off the site plan of concern. One of them being an existing shed, which would be between the proposed new garage and the hydro pole. And again, that shed that is in there is again in an easement or a restricted area. So I was contacted when dealing, asking Hydro Ottawa whether there's been any discussions. I was dealing with the Land Rights Department. And I hope that you've received their correspondence.
Okay, we definitely will be asking staff some questions with regards to this, yes, so that we get some clarity. The Hydro Ottawa is routinely circulated on these applications.
And just because, sorry, Madam, just so I do have a copy of it, and it was addressed to the Committee of Adjustment and sent to your email address.
Yes. We do have a copy of it. We do have that information. Is there anything else that you'd like to add? Sorry, you're on mute at the moment. I didn't hear you. You're on mute.
No, that's it. Thank you very much.
All right. Thank you. Okay. I think I'd like to speak with Ms. Cully. So Ms. Cully, you saw these comments come through. Have you had a chance to find out a little bit more about the hydro pole and the transformer? The committee, we had a chance to talk about this prior to the start of the overall hearing. We just want to make sure that there has been some investigation into these concerns so that we can be comfortable about understanding what the hydro requirements would be. So Ms. Cully, can you tell us a little bit more about that issue? Ms. Cully, you're on mute.
Apologies. Through you, Madam Chair. The email that is being referred to that was sent from Hydro Ottawa provides the image that indicates how far the the dwelling needs to be away from the hydro pole. So that is a minimum of 5 meters. And with the setback being changed to 5.7, it is well outside of that. And it's also the responsibility of the applicant or the developer in this case to discuss with Hydro Ottawa, and that's also indicated in the email as well.
All right. Any questions from the committee on the hydro pole and transformer issue? Are we satisfied that some of our concerns earlier raised? Mr. Hindle?
Yeah, maybe I can ask it directly to the applicant, Ms. Daou. Have you been able to, you've seen these comments, I imagine by now, have you been able to investigate and determine whether the variances requested and the setbacks are in line with Hydro Ottawa's requirements?
Yes, through you, Madam Chair. So I did address this with the designer for the project, and unfortunately, it may not have had time to be circulated to the committee members, but he did do a revised site plan that shows the location based on survey of the hydro location. That was circulated to committee just this morning, so apologies for that, but it does indicate the location of the overhead utility wires and the distances being exceeding 5 meters, which is the maximum requirement from the hydro buffer. And just speaking to provide some assurance as well that the shed, though it's not indicated on the site plan, it's actually being removed. So it's not proposed to remain as part of this application.
All right, okay. Any idea when that shed might be removed, Ms. Daou?
My understanding would be that it would be during the period of construction when they construct the additions to the dwelling.
All right, okay. All right, any other questions from the committee on any of this? All right, I'm going to give you, Ms. Kiefer, just a minute. Normally we don't go back to speakers, but if you'd like to come forward. Ms. Kiefer?
The applicant or?
No, I'm looking because your hands were raised.
Yes, actually, I just want to make sure that they took in consideration that that hydro pole is actually on the property. It's indented from the property line. I want to make sure because that makes a difference when you do the calculations. And also that you've looked at the hydro, there is an engineering a document that clearly states the distance. And my request or our request is that we would like to see Hydro Ottawa do the measurements to ensure that it's done accordingly and that we feel comfortable as a neighbor. Certainly the housing is situated here at 50 Glen Manor, very close to the 48 Glen Manor new proposed building. So we want to ensure that we're safe as well as them. The other thing, I think that would be it. Yeah, that would be it. Thank you very much.
All right, thank you. We unfortunately can't impose that requirement. So part of what happens with our process is we need to get that information directly from Hydro Ottawa. They're expected to have looked at the proposal, to have looked at their existing facilities, and to have signaled to us in any case that there might be cause for concern that in fact they could even ask us for an adjournment. They could say, please adjourn the application until we can resolve this issue and then come back to you with, and we didn't get any of that from Hydro Ottawa. So to be honest with you, our hands are tied at this point. We've heard from the applicant that the designer has been in touch with Hydro Ottawa and that the agency, if they had a concern with those discussions, our expectation would be that we would have had some notice directly from them and not from the designer. So we're gonna have to leave it at that and hope that and trust actually that it was done correctly by the designer and that they know how to do the calculations correctly. All right, I'm going to call out if there's anyone else in the audience who's not on my speakers list who would like to come forward and speak to the panel either for or against the application. You just need to raise your hand and come forward. All right, I'm not seeing anybody come forward at all at this point. So committee, I think we're ready to make a decision at this point. All those in favor of the minor variance application? All right, okay, so the application is granted, Ms. Daou, and it is a unanimous, for the record, approval of the application. What I will recommend, though, Ms. Daou, is if you could share some of that information with the Yuns and with Ms. Kiefer, about the hydro utilities so that they may have some comfort about it. It would probably be just a courtesy to be able to provide them with more information. And with that, I believe we're done on this application. So
thank you very much, everyone.
all right, thank you. Okay, I'm noticing how dark it's getting. The more we're talking to people, the more I'm seeing that the lights, like I had to turn on a light myself, and I'm thinking maybe I should try turning on another, but yeah, in any event. Okay, so we're on application number 9, and this is for 1330 Kilbourne. I believe I'm looking for whom? Number 9, Mr. Villani.
Yes, hello, good evening.
Good evening. So I need to read something to you before we get going. We do not have a statutory declaration from you, so do you solemnly swear or affirm that the notice provided to you as part of the application process and by the committee was posted first at the property to which the application applies for the prescribed number of days prior to the hearing, and that the sign was at all times clearly visible and legible? Do you either swear or affirm that to be true?
I swear.
All right, thank you very much. With that, there is a couple of housekeeping changes to your notice that have been flagged from staff. So we will, I'm going to read this too. It has to do with correction to the legal description on the notice. My understanding is that we are adding part of lot 19 concession or junction Gore, brackets Gloucester, part 1 on registered plan 5R 5138, parts 1 and 2 on plan 5R 32 130. Is that correct?
I'm sorry, could you repeat that, please?
Okay, so we're changing the, we're improving the legal description on your notice. This is what we're proposing.
Okay.
So it's going to read part of lot 19, concession junction Gore, Gloucester, part 1 on registered plan 5R 5138, parts 1 and 2 on plan 4R 32 130.
Yes.
That's correct?
Yeah.
Okay. So for the record, we've made those changes. We're not going to require a presentation from you, Mr. Villani, so I am going to open it up to the committee members at this particular point in time. Our understanding is that this is a reapplication following the lapse of the statutory deadlines. I just want to ask you one quick question, though. Is this exactly the same application as was originally applied for?
No, it's not actually. The difference being at the time of that application, the house was not built, and now the house has been built.
All right, but you're not looking for.
We're just looking.
I think, okay. So the house is built and there's no requirement for any zoning minor variance applications as a result of that construction. It was all good?
It's all good, that's correct. Yes, yes.
Ms. Kelly, can you confirm that you've looked at the new build and that you have not seen any need to flag any minor variances as a result of the development?
Through you, Madam Chair, yes, I did look through it, and the only thing that was the difference was the minor variance that was already applied for the lot area for one part.
All right, perfect. Just wanted to make sure about that. I don't, are any questions for Mr. Villani at this point? Okay, I don't have anybody on my speakers list, so I'm going to throw it out to the public. Does anybody care or want to speak to the committee at this point about this application, either for or against? Now's your chance. All right, not seeing any at this point. Mr. Villani, there are a number of conditions attached to your, you've had a chance to look at them. You're comfortable with them?
Yes, I just had a quick question as I'm all new to this. I believe there's 3, 4, and 5 at the top of my head. I guess if it does get approved, how do I go about doing the actual severance and getting a new deed for the new lot that would be created?
I am going to refer you to our committee staff. It's
okay.
their expertise and they'll
Okay.
be able to help you a lot better than I will. So do call them tomorrow
Okay.
to talk about that. So with
Okay,
that,
perfect.
then, committee members, I think we can take a vote. All those in favor of granting the consent? All right, for the record, the application is granted unanimously. And I think that's it, Mr. Villani. Thank you very much for your time.
All right. Thank you, everyone. Have a good evening.
Okay, looking for at this point, we're on number 10, and I want to do number 10 and number 11 together. I'm looking for Mr. Trinder. All right, so this is not Mr. Trinder. So who have we here tonight? So we've got Mr. Shurkoff.
Yes, my name's Isaac Shurkoff. I'm filling in for Jordan Trinder tonight.
All right, okay, thank you. So I am going to read to you a requirement for the statutory declaration. And I'm going to ask you for two responses. The one related to 1670 Heron, and then I'm going to ask you for the same for a response on 2023 10th Line Road. So with that, do you solemnly swear or affirm that the notice provided to you as part of the application process and by the committee was posted first on the properties, both properties to which the applications apply, that in both cases, the prescribed number of days before the hearing, that sign was up for that amount of time, and that in both cases, the signs were clearly visible and legible for the entirety of that time. So on 1670 Heron Road, do you swear or affirm that to be true?
I affirm.
And on 2023 10th Line Road, do you swear or affirm that to be true?
I affirm as well.
All right, perfect. Just a minor housekeeping change on your notice. Just going to see whether or not it's for both notices. So I'm going to read to you the changes to application number 10 for 1670 Heron Road first. It is in relation to correcting the legal description on the notice. So let me know if you agree with this. It's part of lots 34 and 35, registered plan 31, concession junction Gore, Gloucester, part 1 on plan 5R 5109. Is that correct?
Yes, I believe so.
Okay. And on application number 11 for 2023 10th Line Road, again, correction to the legal description on the notice. It's going to read part lot 1, concession 10, registered plan 11 in the township of Cumberland, part 11, 15, and 22 on plan 4R 14717.
Yes, I agree.
All right. Okay. Thank you. No presentation required from you on these. These are permission applications, I believe. Are these permission applications? No, they're consent applications. So for the 21-year lease extensions. Committee members, any questions on either number 10 or number 11? I'm not seeing any questions from the committee members. I have no one registered to speak for either 1670 Heron Road or for 2023 10th Line Road. If anyone has an interest in the applications affecting either one of those properties at this particular point in time, you can raise your hand and come forward. All right, I'm not seeing anyone come forward. So with that, then I think we can go straight to a vote. Members on application number 10, 1670 Heron Road, all those in favor? All right, for the record, that consent application is granted unanimously. And on application number 11 for 2023 10th Line Road, all those in favor? Yes, it is unanimous once again. So Mr. Shurkoff, Shirkoff, sorry. Yeah, both applications are granted. Any
Thank you very much.
questions?
No questions.
Okay.
Thank you very much.
All right, thank you. Have a nice evening. Okay, we are on to number 12 for 2051 Knightsbridge Road. Looking for Mr. Kennedy.
Good evening, Madam Chair.
Good evening. Need to swear? No, sorry. I don't need to swear. I really don't. But I do need to read something to you. So do you solemnly swear or affirm that the notice provided to you as part of the application process and by the committee was posted first on the property to which the application applies, secondly, for the prescribed number of days prior to the hearing, and finally, that the sign was clearly visible and legible for the entirety of that time? Do you either swear or affirm that to be true?
I do swear.
All right, thank you very much. We've also got a number of revisions to your notice. So I'm going to walk through these for the record, and then you can tell me whether you can confirm or not. So, correction to the legal description, we're going to add, after blocks S and T, lot 57, registered plan 314932, and we're striking 314928. Is that correct?
Okay, yes.
Then in terms of the purpose of the application under the notice, the owners require the authority of the committee for a minor variance to permit a reduced total combined interior side yard setback of 2.93, and we're striking 2.438 meters and adding the word meters, with a southerly setback of 1.18. We're striking 0.914 meters and adding the word meters, and northerly setback of 1.75, striking 1.524, again adding meters, whereas the bylaw requires a minimum total combined interior side yard setback of 3 meters, with one minimum interior side yard setback being no less than 1.2 meters. Are you okay with that change?
Yes, yes, I am, Madam Chair.
All right, perfect. That we have everything. I think that's it. Okay, with that, oh, just a minute. Ms. Cully, can I just ask you a quick question? Ms. Cully, do I need to strike blocks S and T?
Yes, Madam Chair, that's correct. There is no indication of blocks S and T.
All right, okay, so we are striking that. Thank you. I noticed that the summary page doesn't quite match the report, so I just wanted to be sure I was doing that right. Did I miss anything, Ms. Cully, or am I good at this point?
Everything I heard you had couched there.
All right. Okay. Great. So, Mr. Kennedy, we're not going to be requiring a presentation from you. I'm going to open it up to, the members. Mr. Wright, you've got a question. Great. Go ahead, please.
Just one quick question. I'm assuming the dimensions are based on a survey that was submitted. Is that correct?
That's correct.
I don't have a copy of that. A survey by Ontario Land Surveyor?
Yes, sir. It was submitted to the planning department, both in hard copy and electronic. But yes, it was done by Farley, Smith, and Dennis.
Thank you.
All right. I think, in fact, wasn't this one of the applications that we had adjourned to await the survey plan?
Yes, Madam Chair. Yeah.
Okay. All right. Excellent. No one on my speakers list at this particular point in time, so I'm going to throw it open to the public. Is there anyone in the audience who would like to speak either for or against this application? Now's your chance. Just need to raise your hand. All right, I'm not seeing anybody. So with that, then, committee members, I think we can go to a vote. All those in favor of the minor variances? All right, so for the record, the application is unanimously granted. Thank you, Mr. Kennedy. I think that's it.
Thank you so much for your time.
All right, bye now. Okay, we're going to application number 13 for 2865 Walkway Road. I believe Mr. White needs to not be part of these proceedings at this particular point in time. So, Mr. Price, I just have a quick question. Have I read the staff declaration to you enough at this point, or do I need to do it again?
You do need to do it again, Madam Chair. If you'll recall at the last adjournment, it was to buy us some time to get a further an additional application for parts 4 and 5 on the reference plan. Part 5 being the easement, but yes, I had to go and hang new signs, so I am going to have to be sworn.
All right, thank you. I wasn't sure how far we get. We have so much discussion. I wasn't sure how far we got. Sorry, do you solemnly swear or affirm that the notice provided to you as part of the application process and by the committee was posted first at the properties to which the applications apply for the prescribed number of days prior to the hearing, and that the sign was clearly visible and legible for the entirety of that time? Do you either swear or affirm that to be true?
Yes, Madam Chair, I swear.
All right, thank you very much. There's a number of changes, Mr. Price, that I need to get onto the record from the modifications to the notice. So correction to legal description and zoning on the notice. So the legal description should read part of lots 24 and 25, concession 3, Ottawa front, parts 1 to 10 on 4R 33-542. In the zoning, we are adding the IH designation and striking the special exception 263. Is that correct?
Yes.
All right. With regards to the notice, we need to make changes to the description of the remnant lands. So the vacant remnant lands. I beg your pardon? Okay. So the vacant remnant land shown on part 1 on said plan is also landlocked. Part 1 will have a depth of 59.94 and not 59.98 meters. Is that correct?
That sounds correct, yes.
Okay, in a lot area, because there's no more changes to that. Parts 4 and 5 will be 10,495.7 square meters rather than 10,195.7 with and we're striking with a lot width of 59.94 meters. So we don't need that piece. And finally, it is proposed to grant an easement and right of way for parts. So striking the word over, 4 parts 1 and 2 on plan, 4R 33-542. The rest is as it should be, save and accept for the reference to parts 5 and 6. We're going to strike and 6 from the description. And finally, Lancaster Road, application B00319, landlocked, 59.88 meters, 10,195.7 square meters. 4 and 5 to be merged with 2760 rather than 2723 Lancaster Road. Is that correct?
Yes, I believe, Madam Chair, in actual fact, I think to even specify a little more, the property is intended to be transferred through the agreement of purchase and sale to both 2760 and 2766 Sheffield, which are the same ownership entity.
Is that an addition that we should be including on that, or do you think with the manner in which we just proposed it would be sufficient? I don't want to put more if I don't need to put more. Ms. Ramirez?
Sorry, Madam Chair, we just couldn't hear you. Your microphone kept cutting in and out.
Oh, is that right? What on earth is happening? Okay, I'm going to have to fix that, obviously. Get a microphone. Okay, so Ms. Ramirez, I guess I just need to get confirmation that it's not necessary to make any kind of reference to the purchase and sale, or would you like what Mr. Price has suggested added?
The references to 2723 Lancaster need to be replaced with 2760 and 2766 Sheffield Road.
And sorry, that's not on mine. So the Sheffield Road address is what again?
The Sheffield Road addresses were 2760 and 2766 Sheffield Road.
2760 is Lancaster, is it not?
2723 Lancaster is being replaced with 2760 and 2766 Sheffield Road.
Thank you. That's, I thought what I heard. So, okay, we're going to make that change. Are you okay with that, Mr. Price, the way it is?
Yes, I believe so. You did blank out again a little bit with your mic, but I believe Mr. Ramirez is consistent with what we're trying to achieve here. Yes.
All right, thank you. Okay, with that, there have been a number of discussions. We've had a number of emails from staff. So we don't need a presentation, Mr. Price, but I'm going to ask the members who are on whether or not they would have any questions. Mr. Hindle?
I think my only question, we've seen a number of different applications for different parcels in the area. Do we have any more coming, or is this the last of them?
No, through you, Madam Chair, this will be it for this portion of the abandoned rail line. Yes, this finishes it up.
Perfect.
For this portion that is between Lancaster and Sheffield. We're done. Not to say there isn't more on the other opposite end of Sheffield, but we'll deal with that at a later time in other applications.
All right. So you also are aware, Mr. Price, that staff continued to have a concern with regards to part one. All right, and this
part one, the end piece, the remnant parcel, you mean?
Yes.
Okay.
All right. And so, Ms. Ramirez, I just want to bring you to a statement in your report, and it would be on page 3. It is essentially the first full paragraph where you say that staff requests that if granted, the committee stipulate in giving provisional consent that subsection 53 or 5, subsection 3 or 5 of the Planning Act apply to any subsequent conveyance of or transaction involving the same parcel. I just want to make sure that has been addressed in your conditions.
It has.
All right. Just wanted to make sure that that's all there. Okay. Any further questions from the committee at this point? All right, I'm just going to go. I have no one on my speakers list for this item. So I'm going to need to open it up to the public. Is there anyone in the audience who would like to speak either for or against this application? Now's your chance. You just need to raise your hand and come forward. Okay, and I'm not seeing anybody. So committee members, I just want to be sure we're satisfied with the conditions. We understand them, I think, at this point. And okay, so Mr. Price, yes, go ahead, please.
Yes, and I'm sounding like a broken record with all these applications, the previous ones that were granted, as well as the ones before you this evening, as it pertains to condition 1 and staff's request for a grading and drainage plan as a condition of the severance. Similar to the previous severance to the south that were granted, that condition was removed. It's better served at the time of site plan approval when these new lots are merged with the new properties and future development applications by way of site plan come forward. So we're just hoping for the same treatment with these ones.
All right. So committee members, we did have a chat about this in the pre-meet. So I'm going to put out for a vote, all those in favor of deleting condition number 1. So Ms. Markovich, Ms. Willis, and Mr. Hindle, you're all in favor of deleting condition number 1. I am dissenting on that decision. So in which case, I guess that needs to be reflected in the decision. Okay. So with that, then I think we can go to a vote on the actual consent applications at this point. So all those in favor? Okay, all right. So for the record, there is a unanimous granting of the application with the removal of condition number 1, to which I'm dissenting on that. Otherwise, I think we're done.
Thank you so much, Madam Chair, members of committee and staff. It was a long, convoluted, complex, more complex than it needed to be. So I appreciate everybody's patience with us. Thank you so much. Have a great night.
I'd like to thank you and Mr. Leal and Ms. Ramirez for all of the work that you have put into this application. And we truly appreciate it. The committee's really, it's important that we understand that, that when we look at these things, I know they're complex. It takes some time even for the committee to understand sometimes how this all works. But thank you. We got there. Great work.
We're
Thanks.
done.
Please fulfill your conditions within a year.
No problem there. We've got deals to close, and that's why we were before you. So now we've got to get the notices out because we've got closings at the end of the month. So it's done. Thank you very much, guys. Appreciate it.
All right. Thanks so much. Okay, we're going, we're moving ahead here. So we've got application number 14 and 15, which I'd like to hear together. And I think we've got Mr. Church who can bring us through those applications. Mr. Church. Good evening.
Good evening, Madam Chair.
All right, so I am going to read the statutory declaration to you, and then I'll ask you for a response to both application number 14 and then application number 15. So do you solemnly swear or affirm that the notice provided to you as part of the application process and by the committee was first posted on the property to which the application applies, that it was there for the prescribed number of days prior to the hearing, and that it was clearly visible and legible for the entirety of that time? Do you either swear, and now I'm specifically with respect to 3000 Navan Road, do you either swear or affirm that to be true?
Yes, I affirm that to be true.
Okay. And with regards to application number 15, hang on, for whatever reason, it seems to have disappeared on me. 6101 Renault Road, 2980, 3060, and 3080 Navan Road. Do you either swear or affirm that to be true?
Yes, I affirm that to be true.
All right, perfect. Okay, so we have the both applications. Just want to make sure I don't have any changes to make to the notice. I don't see
Actually, we do, Madam Chair.
Okay.
We had alerted the Committee of Adjustments staff to that some time ago. Ever since the applications were submitted, Kaivan has since closed on the lands. So on the notice for 6101 Renault Road, it notes that the owner is Kaivan Renault Incorporated and in brackets under agreement of purchase and sale. So the portion that says under agreement of purchase and sale can now be struck out because they are now the owners. With that as well, because Kaivan has closed on the lands have merged on title with a couple of other parcels that Kaivan had previously purchased at 3048 and 3054 Navan Road. So the location on the notice should be amended to reflect that. There's also in the notice itself, it does make reference to all the addresses. I believe it's on the second page, paragraph 3, that it lists out all the addresses. So again, we'd have to add 3048 and 3054 Navan. The same thing would have to be done for the notice for 3000 Navan Road, which also on a couple of occasions lists out all of the properties that are part of the 6101 Renault lands now. So again, 3048 and 3054 Navan Road have to be added to those descriptions.
All right, thank you, Mr. Church. Ms. Williams, I just want to make sure that was a lot of information, not something that's before me. So Ms. Williams, I want to make sure that you have what you need.
I believe so, Madam Chair. If I have any questions, I will get in touch with Mr. Church.
All right, thank you very much on that. Okay. So, Mr. Church, we are not requesting a presentation on either application number 14 or 15. I think we've had a chance to look at it in some detail. We understand where the swaps of land, if you will, are occurring. So I'm going to just open it up to the committee members at this point. Does anyone have any questions for either application number 14 or 15? All right, not seeing anybody come forward. With that, then, Mr. Hendel.
I believe I see
sorry.
Mr. Hendel, yeah.
No worries. Quick question, I guess, from a process perspective, is the intention, I guess, that even once this transfer takes place, that the lands that will then be owned by the purchaser that's listed as the block, that'll still be continue to be included in the plan of subdivision?
So the lands that will be conveyed to Kaivan, to 6101 Renault, are going to be part of the draft approved plan of subdivision. And actually the block that is going to be conveyed to 3000 Navan. Hold up, I'm just
I think it's block 66.
Block 66. I just wanted to double check that. So it is listed. It is listed as an open space block, and it will continue to be owned by the owners at 3000 Navan Road.
Okay, well, that's fine. Then I guess maybe I hope that the answer is fine, but a question maybe for the Secretary Treasurer or for the coordinators, because we do have this merger, I just want to make sure that that doesn't toy with our circulation list that we may be required to. I think it's likely okay in this case, but I just want to confirm from your experience that that's correct.
Madam Chair, I don't believe that there is any impact on the notice as a result of the merger.
Okay. Nope, that's good to know. I just wanted to make sure and double check because I know that was an issue from the last time around we missed a property. But at the very least, sounds like it was accurate at the very least when it was issued. So there's that piece of safety.
Right.
Okay, perfect. I am good to go.
All right, thanks. Sorry, I had to turn on some light because it was just getting too dark in general. So, okay. So with that, anyone else, any questions before I go to the public on this? All right, so no one on my speakers list for either 14 or 15, but if you have any concerns, now's your opportunity. Just need to raise your hand and come forward. Okay, I'm not seeing anybody come forward at all. So on the consent then for 3000 Navan Road, all those in favor? Okay, so for the record, that consent application is unanimously granted. And on the next application, which is for the 6101 Renault Road, just going to leave it at that. All those in favor? All right, again, for the record, the application for consent is unanimously granted. I think that's it. I see one condition in here for lot line adjustment under section 5012. Any questions about that, Mr. Church?
No, Madam Chair. Kevin has reviewed the condition and they are fine with it.
All right, perfect. I don't see anything else that we need to discuss. So with that, good luck with your development plans.
Thank you, Madam Chair. Have a good night.
Have a good night. Okay. Then our last applications, but we're going to hear them together, is 16 and 17 for 248 Furland Street. Mr. Hume.
Madam Chair.
All right. Need to read something to you. Do you
Okay.
solemnly swear or affirm that the notice provided to you as part of the application process and by the committee was posted first at the property to which the application applies for the prescribed number of days before the hearing, and that the sign was clearly visible and legible for the entirety of that time? Do you either swear or affirm that to be true?
I swear that to be true, Madam Chair.
All right, perfect. Number of changes with regards to the notice. So I think then and it has to do with the variances. So I'm going to read some of these changes to you. And then if you can just confirm, I don't think there's any legal description change here. Hang on. All right, but for variance A, we are changing it to permit a projection balconies to project 1.14 rather than 1.92 meters into the required rear yard. Is that correct?
Yes, Madam Chair.
For C, variance C, to permit a reduced interior side yard setback of 0.67 rather than 0.65 meters.
Correct, Madam Chair.
For variance E, to permit a projection balconies again to project 1.14 rather than 1.92.
That's correct, Madam Chair.
And lastly, again, well, a little bit different. For G, to permit a reduced interior side yard setback of 0.65 rather than 0.67.
That's correct, Madam Chair.
Okay.
Sorry,
So
those variances just got flipped from one side to the other. It was just it was more of a clerical error.
all right. So Mr. Hume, our understanding is that you have had a chance to revise the plans.
Yes.
From the original. So
yes,
we're going to ask you for a brief presentation if that's okay.
Absolutely. Absolutely. Okay. So, Madam Chair, I have a slide in front of you that shows the site plan and the elevation. You'll notice at the rear, the open air deck has been reduced, and in accordance with trying to meet the direction that that city staff have brought forward, we've reduced the deck and we've eliminated the stairs. So, which I'll come back to in a bit of a second. Now, Furlong's a very short street. It's a dead end, and it only has 12 homes on it, of various states of renewal. But what we try to do is to make the revisions, not make them, they are now zoning compliant. So what happened was the front doors came down to the street level, as you can see on the elevation. This building has no basement, so there's no basement unit, so everything is above grade. In doing that, we uncovered I think it's a quirk of the zoning bylaw, but others may not. But in the R4UH zone, for lots where the parent zoning width is 6 meters, regardless of your lot width, you can't have a driveway other than a shared driveway, and I think it's of 1.5 meters. So that meant that we couldn't have a driveway in the because our parent zone shows lot widths of 6 meters, and regardless of the fact that we are actually larger than 6 meters. So what we've done is we've converted that to soft landscaping, and that's where we'll plant the 2 trees that have been proposed. And we've left the former garage spaces open because some of the changes that to address the staff's concerns, we had to make some compromises. So if we go to the next slide, and I'll take you right to the rear, the rear portion of the with the next slide. Yeah, there we go. So as you can see, what we've got is we've got stairs, or not stairs, sorry. We've got balconies on both the second and third level. And if you look at the staff comment is, they're not a big fan of the balconies. They would prefer if we eliminated the third balcony. If we eliminate the third balcony, we run into a building code conflict, because a section of the building code requires us on the third floor to have a means of egress to the building. So that would mean that we'd either have to have a balcony within the frame of the building, either at the back or at the front. And when we looked at that, and we did model that, the compromises to the interior spaces were just too significant for the owners. So that led us to look at what if we were able to have a permitted projection in the rear yard. And I should notice that a projection is permitted for lots over 30 meters in length. This is 29.11. So it's quite a small difference in what we're looking at here. And when we looked at the context of the rear yard, when we looked to the west of our property, our overlook is a parking lot. Immediately to the back of us, we have a building on the property line, and the overlook to the other rear property at 255. We've talked to them, and they've issued you a letter of support for our designs. So, we've had to make some significant compromises to make this zoning compliant, but we can't address all of the city staff's concern because we need that third floor egress for both of the units to meet. And I have the code reference. It's building code reference 9.9.9.1. So that's where that is the primary variance that the city has a concern with. We do know they have concerns with some of the urban design elements, but we think that by bringing the front door down to the ground level, the planting of the trees, the fact that the only way in and out of this building, if we go to the next slide, is going to be, for the primary units, is going to be via the front door. In essence, what we'll find is that the spaces that were formerly garage spaces, we think will have to become almost like porch spaces. We believe that's where you're going to have your barbecue, where people are going to come out, because it is the two front doors are the only way you're able to access the exterior of the dwelling unit. So porch spaces in the front for the primary unit. The SDUs will have the rear yard amenity space, and we think that although not, we would prefer to have driveways. In this case, when we look across the street at our other properties, we think we've got a fairly compelling case that we're really animating the street in a reasonable and proper manner. So I do have some pictures on the last slides that give you a little context for the rear, and you can see the first two are directly to the west of us. The and the other three are directly across the street, elevated porches, recessed entrances. So we think that we're going to be, we can address or we have addressed the street elevation or the street animation issue. So Madam Chair, that would be my, in closing, I think if I could just address the four tests of the act, I think are the variances minor? And I'm glad they were able to show this last one. This is just down the street where people are out on their front porch. You can see the barbecue right next to it. So, it's not an uncommon thing to have these front porch spaces, certainly in this neighborhood. And we would expect something quite similar to occur in these spaces. So if I can conclude by the four tests, Madam Chair, are the variances minor for lot area, for the side yards and for the rear yards and the encroachments? I believe that they are minor. Are the variances desirable for the appropriate development and use of the property? These are ground-oriented, family-style, semi-detached units. They're appropriate in these areas. We're having to grapple with some what I would call design issues, but I think that the variances now that we're asking for are appropriate and desirable. I believe the general intent and purpose of the zoning bylaws is maintained. Overlooked issues are minor to non-existent. The rear yard is grass. It's not, as in our neighbors, filled with buildings and or asphalt. And I think that the general purpose and tenet of the official plan is maintained. This is a general urban area. It supports intensification, and it certainly gives preference to ground-oriented family-style housing.
All right, thank you, Mr. Hume, for that presentation. I'm going to just open it up to the members at this point. Any questions? Mr. Hindle.
Sure. Yeah, I've got just a couple. I'm curious with the main floor, and it looks like we've just taken the existing, what was designed as the garage space, and just converted it to storage. Well, is there a reason why that hasn't been adapted into, say, another bedroom for the lower unit and used as kind of more useful space? Or is the intention that over time this will then be converted into a garage?
Well, it can't be converted into garage unless the property is rezoned. So in the zoning bylaw, and we've run into this before, you couldn't apply for a minor variance because the bylaw is a prohibition. So we couldn't say, yes, you're going to permit a single lane driveway because the zoning bylaw doesn't permit it. So it wouldn't meet the third test. Is the general intent and purpose of the zoning bylaw maintained? Because by permitting a driveway, you can't maintain the intent of the bylaw when the intent of the bylaw is absolute prohibition. So there can't be a driveway, ergo there can't be a garage there because there's no way to get there. We've left. I mean, we didn't have time to re-demise the space because we had a very short period of time with which to do that. But what you'll see on the elevation is we've left that space open. We've left large windows and a single door so that we could redesign that space. Because because we eliminated access to the rear via the stairs to comply with the city's wish that we reduce that encroachment, there's only really one way out of the primary units, and that's through the front door. So you're not going to get people coming out of the front door walking all the way around the building to the rear yard, and settling down for, whatever they're going to do, because to access back into their unit, to go to the bathroom, to get a drink, to do anything, you're going to have to access all the way around. So we think that that front space is actually going to become a more of a porch space. That's where you're going to come out. You'll have your sitting area. You're going to have your barbecue, because if you look at although the floor plans that were provided by the committee, those two front windows at the top on the second floor, that's your dining room. So, everything now is, your kitchen is in the middle, your dining room's at the front. So you're going to be able, that's where you're going to have the front of, that's where you're going to have those people in their front amenity space.
Okay, well, I think you kind of preempted one of my questions, because I think in this case, as you described, if you're thinking of the storage space, or what is the fundamentally a garage space, and using that for what you're describing as outdoor kind of uses of barbecues and that, but it's an indoor space. So how do you anticipate that working?
Yeah.
Why would you leave your unit on the second floor, which has a nice dining room, to go downstairs outside into an indoor dining room?
Well, I'm not saying all of it's going to be indoor. I mean, we haven't re-demised the space. There's going to be, it doesn't have a basement, right? So this is going to be, some portion of it will be storage. Whether we add an additional door on the side and demise the space to allow for storage and access to, I think there's a mechanical room on the ground floor that's in that space. So whether we re-demise that space and shorten it up to provide storage for both the ground floor unit and the second story unit, we're just not there yet, right? On how to do that. I think it's more, we've given much more thought to how the front space is going to be used as a practical matter.
Right. Yeah. And so I think you brought up to, I think my other concern, which is access to the rear, because I think fundamentally it seems like there really isn't much. Like, we're not really anticipating that the rear yard is going to be easily accessible by any of the units outside of by the side yard.
Right. Absolutely. Okay.
Yeah. And it's, I understand why you removed the staircases and did that, but I'm concerned that I think between these two changes to make it zoning compliant in kind of a quick and dirty approach, especially if we're going to tie variances to plans, which we often do,
right?
I'm kind of concerned that it's not really a workable or a desirable piece of development, because you've got a dead space in the front that's storage, which fundamentally I think a garage would be the same. So that may not change the animation portion, but the usability of the structure and its relationship with the neighborhood seems like it might be a little tenuous.
I don't know that I agree with you fundamentally that the front space is going to become the primary space of the primary unit, and the rear yard space is going to become the space of the secondary dwelling unit in the back there. So I think that's clear. As soon as you eliminated the staircase, that was going to happen.
Mm-hmm.
So and city staff were pretty adamant that they don't like that. And I recognize that it's in the purview of the committee to decide what they like and don't like. So with respect to, though, you can tie the variances to these plans, and that building footprint will be built. There is no, we're comfortable that you can tie your variances to the plans, and that there is not going to be from our perspective, an issue achieving the building form. But if you're telling us go away and come back for another variance on the rear to allow better access to the rear yard.
No, I hear you. Yeah.
It's that zoning and trying to make it zoning compliant was a big effort. And you're quite right. Compromises had to be made. So.
Yeah, and it's kind of unfortunate because even in the rear, we've got this blank wall on the main floor. That's really, it would be nice to be engaging with the actual backyard and have direct access. But I see the tension that's been working its way through.
Yeah, and now I should say though that you know, the rear, as the rear has gotten as the rear projection has gotten smaller and the stairs came away, that presents some opportunities for us to introduce, to maybe change the way the ground floor unit is established, allowing an access from the sliding doors from the bedroom out, because it's a shorter space now, right? And so it's not covered over, and it's not bisected by the stairs. So there are opportunities to enhance that, and even just with the addition of glazing, if we were to do that. We just haven't had time to sort of explore those out. And I will be honest, we were really thrown for a loop when we got told that, hey, you're not zoning compliant with the driveways, and we had to seek some advice as to whether we actually could apply for a minor variance. And the advice we got was, no, you can't. You would need to rezone the property. And so we're and we don't want to lose we didn't want to lose the opportunity. So we're
fair enough. So maybe what I'm hearing then is there might be a benefit in not fully tying to plans, but tying to kind of footprints and maybe the balcony and above. But at the very least, on the main floor, there is potential to maybe improve the layout to improve how the property is built in. So we have, if we leave it with some flexibility in how we approve, there might be some possibility of improvements overall. Is that about right?
That's fair. I never really thought that tying it to plans tied the glazing as tightly as maybe some do, but yes, we would be amenable to that. Okay.
Yeah, because I know we've been in the practice, at least fairly recently, of tying to plans fairly closely, especially when there's this many variances. So, so that's a good distinction to have. Maybe I'll leave it to the rest of the committee, and then we can discuss more.
All right, thank you, Mr. Handel. Ms. Markovich, I see that you've some
Yes,
questions.
thank you, Madam Chair, and glad to hear that you're amenable to that. I guess my question, you had mentioned it's a relatively short street. I think you mentioned 12 homes, especially I think given the discussion around how the proposed front of the building is anticipated to be used. I'm just wondering if you could talk a little bit about your approach to consultation and what you heard from neighbors, if any feedback was provided, and if any of that feedback presents in the application we're seeing here today.
Well, we heard from two sets of neighbors. The owners went out and talked to the neighbors. We heard from two of our backyard neighbors, and they were very supportive of the original proposal. So we really got no negative feedback on the original proposal. Now, we haven't gotten, they haven't seen the no parking version. And, I think that might generate a little bit of interest, because now you're not going to have parking. But if you're going to build semi-detached, which is, sort of what a lot of neighborhoods like, semi-detached, ground floor or ground oriented family housing, at least in the R4 UA zone, you're not going to be allowed to provide parking or provide driveways And so we may be the first, but we're certainly not going to be the last in that environment, unless the city changes its zoning.
Okay, thank you. So just to clarify that the neighbors saw the original, but not this revised.
Yeah, so the neighbors, specifically the backyard neighbors, they saw the ones with the large patio or large deck and large staircases into the rear yard.
Okay, thank you for clarifying.
All right, thank you. Anyone else? Questions for Mr. Hume? I guess I'll jump in and just make a couple of comments. To be honest with you, Mr. Hume, I'm never really as concerned about the number of variances in a proposal. I'm often more worried about what the outcome is going to be. And in this case, I would have preferred your original proposal over this one. And in fact, to the extent that I'm really worried that this one is not a good result at the end of the day. We don't know enough about how those two dwelling units will be used. I noticed in your floor plans, you're looking at a master bedroom with 2 bedrooms. We're talking families moving into these units without having really a good idea of how the overall site is going to function. Thinking about waste storage, I was thinking about sport equipment, all that stuff. Like, so normally family baggage, like I'm not sure I kind of understand how the units the way they've been essentially proposed is going to work that well. But that's just, that's more of my personal preference in terms of how to proceed with these kinds of more complex sites, because you've been handed you've taken on a very challenging development project.
So just that space in the front, unless we rezone it, and I don't think that the owner doesn't have an appetite to go through a rezoning to permit that to be a garage. So it's going to be repurposed into spaces for garbage and storage, and that's where things are going to naturally they're going to be stored there, and it'll be a shared space between the secondary dwelling unit and the primary unit. It was more as you got out into the front of the building that is of how is that going to function? How's that going to be animated? And the fact, regardless of what we do in the rear yard, that space is going to exist, right? Because we're not going to be able to put driveways there. It's going to exist in some fashion up until the building face. Now, what happens past the building face? Is it storage? Is it mechanical? Is it barbecue? Is it porch? That remains to be seen at this point. But that space is going to remain there unless there's a rezoning, which I don't think there's going to be.
Well, I mean, I think, Mr. Hume, what I'm really getting at is, we're talking a lot about a semi-detached dwelling unit, but in actual fact, there's all kinds of different housing forms out there that could be proposed for this site that I think probably could be better designed. But anyway, that's just that's just sort of a personal thing. I don't have anybody on my speakers list, but I need to open it up. Unless members have any questions, I'm going to go to the public at this point. Mr. Handel.
Yeah, actually, I think you brought up a good point, Mr. Hume, of garbage and disposal of that. I think normally we would say the garage handles that, but we've lost that. And I know it's a concern, especially on the urban panel, talking about, really only approving buildings once there's a clear plan for garbage, bicycle parking, some of these kind of key items. So I think overall I understand how we've gotten here and where we've gotten, but I'm a little reticent to sign off on these plans as presented without some of those kind of finer grained details that I think, as the chair brought up, are going to be kind of important in how the site kind of operates. So I'm happy to open it up to the public, but I'm a little bit, I would be tempted at this stage to maybe ask for an adjournment, to have you go through and update some plans to tweak and finalize some of these kind of questions and concerns, and then kind of move forward on that basis.
I can bring back a set of plans that have, more glazing and elements. They're not going to affect the variances for sure. I mean, because we're not going to be seeking more variances. And we can change or address a little bit of the floor plan issues for you. I guess my question to you is that going to change the principles of the variances, right? Is it going to be, do those things make the rear encroachment more, not more acceptable, but if it's not acceptable now, will it make it more acceptable? And the lot, the depth, sort of the rear yard, the side yards. So we're just, I
yeah, no.
And I'm happy to do it. I just
yeah, I tend to agree with you. I think overall the end result would be the same, and I think the variances and the footprint are fixed, and I kind of accept that. I think where my head is at is I think this is starting to move into a bit more of an urban context where there's a bit more of some of those urban questions that need to be answered that the floor plans as provided don't necessarily address. And so that's the garbage and some of those other items that come up fairly regularly on other panels that we don't necessarily deal with too much. And so I'm a little bit, I'd be reticent to go ahead and approve without some of those finer details being in place. Because I think ultimately how those function is indeed key to whether this building as a whole, inclusive of the variances that we are being asked to sign off on, whether they operate and are fundamentally or desirable for the neighborhood. And I think that's the question, is whether it's desirable. And if you have garbage out in the front because there's nowhere where to put it, that's not desirable. And so I think that's the portion of the test that I just want to make sure that we're addressing. And I think there is absolutely an ability to do that in this case. There's a real benefit in some respects from not having parking. You have green space and landscaping and whatever, but there are other impacts that still need to be addressed. So I think that's where my head's at, but I'm open to be convinced otherwise, or to hear from the rest of the committee and how they feel.
All right, so I have questions from Ms. Willis at this point.
Yes, Madam Chair, I tend to agree with the applicant that the additional information is not really germane to the variances being sought. I do agree with Mr. Hindle, however, that it is a big problem with increasingly so with more development on smaller lots with where you put all these things. So I'd be interested in hearing from the applicant what, if we did proceed and you did some more work on the plan, whether that causes you any problems in terms of timing of the progress of your project.
Not really in terms of the timing perspective. I mean, this is the second time we've been back to the committee. I not want to come back. I don't really want to come back a third, but and the timing, to be fair, is not really on your end. It's the lag that once we get this done and getting clearing all the conditions and all the other requirements that tends to drag and get onerous. But if you're, so it doesn't give me, you're putting me in a spot where I'm going to have, where you want me to come back with a floor plate, right? So I'd rather
All right.
not do that. I'd rather not do that, but if that's going to be the decider that the committee is, if that's going to be the decider for the committee, then, you know, well, I'll take the committee's advice.
Just on that though, you will have to do it in any case to deal with the construction of the unit. So you've obviously put a lot of thought into it, even though it was a sort of a last minute surprise about the impediments that you're facing. But if you need to do it and you need to do it fast, it may mean, I don't know how much of a delay it would be, but I would support the adjournment as long as it's not putting you in a bad situation.
My only, and this is not your issue. It's my issue. My designer's about to have a baby, and once he has the baby, he's off for 3 weeks. So really, so I'm trying to juggle to get all of this done before the designer goes on, and he's actually listening. So tonight, so you know, maybe we can adjust that floor plating. You can get that done before she has her baby, and he's going to take some time off, and I totally understand that. So, but if we had to work around that, that's a workaround. So. No.
All right, so I think at this point, Mr. White, I just want to give you a chance before I move on.
Thank you, Madam Chair. I mean, just a couple of thoughts on what the bylaw appears to want to happen in this part of the city. The only minor variance we're being asked to deal with in terms of the lotting itself is with respect to reduced lot area, and that's only to the extent of 2.5 square meters. So it's pretty obvious to me that the intent is to accommodate, intent of the bylaw is to accommodate, somehow accommodate semi-detached dwellings on this property, and accommodate the type of development that's proposed on this property. It's unfortunate that the bylaw, in my view, doesn't permit the accommodation of parking when you're constructing 2-bedroom residential units with 2 bathrooms and everything that a reasonably sized family would expect to have, that you wouldn't accommodate parking for at least 1 vehicle in each unit. But and in any case, you know, I think, as I said, the bylaw is intended to accommodate the type of development that's proposed. I think the variances that are being sought with respect to encroachment of balconies and even with respect to the side yards that are required are reasonable. If we weren't dealing with the design that we've had to see, I'd be inclined to say that minor variances are appropriate based on a building footprint. I mean, that's my position on it, that I'd be inclined to support the minor variances as they are. It's unfortunate if we, in my view, that if we tie this to the plans that we see, I don't think we're doing the right thing there.
All right. All right. Thank you, Mr. White. Ms. Markovich, did you want to pipe in before we go to the public?
Yeah, thank you, Madam Chair. I mean, just to echo, I think what Member Hindle has suggested, I would be very supportive of that idea. So if that's a possibility that we can explore here, then I think that's a good outcome.
For an adjournment, like a further adjournment? Okay, all right.
Yes, thank you.
Okay, I'm going to go out to the public and then we're going to come back. I don't have anybody on my speakers list, but is there anyone in the audience who would like to speak either for or against this application? Now's your chance. Yes, Ms. Gillis.
Hi again. Sorry for not having a video feed.
Gillis, can I just get you to give us your municipal address?
Yes, Lori Gillis, 208 Hannah Street.
Okay.
In Vanier. I have concerns with this type of development, otherwise known as infill. And I frankly don't want to see them in my neighborhood. So I don't know the exact language to direct my specific grievances about the rules that the committee uses to agree or not. But looking at the plans that were presented today, the picture on page 1 of this evolution design and drafting shows no bungalows on either side of first of all, it looks like a triplex, not a duplex. It doesn't show the houses adjacent to it and how they will be affected by the use of the space. And I don't understand how it's possible to have so many windows added to the sides of a new building that are going to be overshadowing the 2 houses on the side. I don't understand also how it's possible, like when you go to the landlord tenant board, you can't just say, oh yeah, my neighbor or my other tenants are okay. You have to actually provide some kind of evidence that they're okay. They have to present themselves or supply a letter. And even at that, the letter is barely accepted. So I'm very curious to know, and I have some particular training in these types of proceedings. For people in my neighborhood, do we really think that they understand these types of proceedings and what's at stake? And that's just saying that the neighbors on either side are okay with this plan is sufficient for the Committee of Adjustment to make a decision.
So Ms. Gillis, the city's always been aware that part of being able to be effective in terms of providing consultation and input into these processes is to be sure that, in fact, community associations and any members of the public actually have an opportunity to learn it. And so the city had for years what was essentially a series of planning 101 courses where you could in fact participate. I think they were even free. I don't think there was any cost. And that's very helpful. A lot of community associations make a point of making sure that their members would be in fact well versed in all that. And the idea being that members of the community can come, obviously anyone can approach the committee, but the idea was really that the community associations at the very least would be well placed to represent the concerns of the community. So I don't know where that is today, but I'm sure with our COVID world that we're in, none of that has been taking place, obviously, in the last few years. So is there a real lack? Yes, there is. And in my mind, I think the minute that we can get back to business as the new usual, that something like that be brought forward, if not an in-person, which sometimes is more helpful, but at least a video. And we, in fact, as a committee have been talking about doing that. There's a cost attached to it. We don't necessarily have the budget to allow us to do those kinds of things, but your point is well taken. And certainly it's our intent never to try to make these decisions, when members of the public are telling us that they don't understand the process. So I don't know what's available, and what I'll ask you to do is to reach out to our committee staff. They might be able to provide you with maybe other, like it doesn't need to be the city of Ottawa. There might be other municipalities out there who have videos posted that you might be able to learn.
I'm not looking for an education. I'm looking for an answer to, is it sufficient for the committee to make a decision based on someone's just verbally stating that the neighbors were okay with this?
No, the committee has been around for a while, so we tend to know when there is useful evidence versus that hearsay evidence. So that's why we ask very pointed questions about what was the consultation, what was the approach, what were the dates, what were the responses? Do we look ourselves into the files to see whether or not we've received those things? So all of that is, the committee weighs the evidence based on the extent to which the evidence is useful and of value. So I wouldn't worry too much about that. But in terms of, okay, so you don't want an education, but you don't like infill. So I'm not sure how to. I'm trying to be helpful. I obviously not being that helpful at all, but not sure how to respond.
Are you guys saying that the bylaw people approved the footprint of this design, and the only question is the details around the staircases and?
No. So, for example, part of the variances are to talk about interior side yard setbacks. So every one of these variances is essentially not in the, so the bylaw is a standard, it has its standard provisions. And when the minor variances come forward, it's because they're not their proposal is not meeting the bylaw. And so it's the committee who makes a decision about which relief from the standard that the applicants can get.
Yeah. So I have a new homeowner that bought the house next to me who decided to rent it out to at least 8 people. And there is a rat problem in Vanier, and the new homeowner just wants to get his rent. He's a lovely person. He just wants to get his rent. But speaking to this issue of not planning for where garbage goes, and they also have a garage that could be converted to a coach house if that policy is allowed to continue with the city of Ottawa. It's like literally a nightmare that these developments need to actually plan where the garbage is going to go, especially if the city can't actually do anything about rats, and it goes back to the actual individuals in those buildings to control them. There needs to be green space, a space to contain garbage. And lastly, if this is adjourned, does that mean members of the public will have an opportunity again to weigh in before you vote?
Yes, that's exactly what would happen.
Okay, I'll stop bothering you then. Thank you so much for your time.
If it's adjourned, so we're not, so that decision hasn't been made either yet. So we were just trying to get input from the public at this point before we go back to that question. Is there anyone else in the audience who would like to approach a committee on either the consent or the minor variance applications for this property? Okay. I am not seeing anybody else come forward, so I'd like to come back to the whole adjournment proposal. I'm going to go out on a limb here, and I'm going to tell you, I don't think an adjournment is going to be helpful for me necessarily. So, so all those in favor of adjourning this application further, we can talk about a date. I just need to see. All right, so that vote fails because there's only 2 of you, which means that we're making a decision this evening on the applications. So with that, then I'd like to go forward with the application for consent. All those in favor? All right. So with the exception of myself, I am dissenting on the consent, and the reasons is that I do not feel I've had sufficient evidence to convince me that this is orderly development, and that it's essentially compatible even with its surrounding. So with that, on the minor variances, all those in favor? All right, so the minor variances, looks like we have a fail on the minor variances. So you get the consents. The minor variance has failed. So, Mr. Hume. So for the record, I too was denying it. So for the benefit of the coordinators. So Mr. Hume, you get your consent, but not your minor variances.
Right. Okay.
So you know what, I'm going to wish you luck, Mr. Hume, because you do have your consents, and and maybe if you can work with your clients to come up with a different design. Come back to us.
So just out of curiosity, Madam Chair, you can't file an additional application presenting the same variances and just a different floor plate, can you? I mean, and the reason I ask is because normally during a term of council, you can't consider the same matter twice, right? So
you might have a very good point. So you're right. It might be that if the intent is you can't come back to the committee with exactly the same thing, just maybe with a very nuanced kind of information. I'm going to get Mr. Belmar to weigh in on that, if you could, please.
Yes, Madam Chair.
So on whether or not, so in terms of a reapplication for Mr. Hume, what's the rules?
I guess it would depend on how similar an application was being brought forward. But if the committee is considering a new application and there are differences between what was previously presented, I think that would not be an issue.
Right.
Mr. Hume may want to, seek independent advice on that. The committee regularly hears applications that have been heard before. For example, on consent applications that have been refused in the past, or that have been that lapsed because of the conditions not having been cleared in time. So I don't recall something under the Planning Act that would explicitly prohibit the committee from hearing an application that would be submitted once again from the applicant. But I imagine that application would not be identical 100%.
Yeah. Okay. But the key test would be the variances couldn't be the same, I'm assuming.
No.
But in the case of the lot area, it would have to be, right? Because so the lot area has to be. So we've got consent to sever.
to do non-conforming lots.
Yes, we have two new non-conforming lots. Okay, well,
Oh my goodness.
thank you.
Mr. White, before we go, Mr. White, I see your hands up.
Thank you. That begs the question of what can be done with the lot that we've just created. What can be done on the lot that we've just created in terms of a building? We've created a legal non-conforming lot by approving a consent. That's difficult legal. That's a legal question too.
Yeah, I have a feeling that it's not going to go well. But anyhow,
I share that, Madam Chair, but it is what it is. So
anyway, thank you, Mr. Hume. We do appreciate the, first of all, with the lateness of the hour. So our apologies that you're hanging in there to get this kind of result on your application. So thanks for your...
Been there, done that, so I've been in your chair when this has been exactly the same thing. So.
All right. Excellent. Thank you for understanding. And with that, then I guess I need a motion to adjourn from somebody. All right, Mr. White, and the seconder from Mr. Hindle. So we are adjourned. And as usual, I'd like to thank staff for your time, planning staff, coordinator staff. So thank you, Ms. Young. You've been hanging in all night, and Ms. Cully and Ms. Ramirez for your support as always. So have a great evening, everyone, and we'll see you in a couple of weeks.